very much. And I'm chairing the session with Frank, so I'm going to give you, well, let me say thank you for that introduction. I'm so pleased that people have turned up this morning. I thought by Thursday everybody would be wandering around and a little bit tired, so it's nice to see you in attendance and equally thinking what it's going to be to turn up. But we are together, and I look forward to that. And as I said, I'm sharing 2 hours before coffee with Frank. So, and Frank's going to discuss specific subject, whereas I'm just going to wander through some of the fundamental principles. You know, I am not going to lose myself in the small print of this subject, and so much insurance is in the small print of policies. But I'm just going to look at the legal framework and highlight some of the essentials so that one understands the framework, you know, and within that framework, there's a lot of small print. And yesterday we ended up talking about piracy. Piracy is insurance. And then when you have insurance, when you have piracy in the small print, you've got to decide what piracy is. And it isn't necessarily what we see in the Oxford Sea Convention. And it can be very different. Right? So much of insurance and major insurance disputes is about the meaning of the words in the policy. Right? And that in the common law we call that construction. Right? From the verb to construe. And well, it's interpretation more generally. We have these fashions with language. We talk about the interpretation of a statute or an international convention, and we talk about the construction of a document or of a whole draft. So I've got PowerPoints, and they're not as professional and as elaborate as some of my colleagues. But I'm not going to go through them all. I'm going to be very selective. We have 60 minutes, and I'm going to try and render them complete and effective 60 minutes. So I think the PowerPoints will be for everybody to go through. And so I'm picking and choosing, okay? And I'm not very good with the technology, but I'll do my best. So, the most difficult thing, I'm going to talk about insurance, and we can't define insurance. It's a nightmare. And we give them up. How do you define insurance? Right? Well, it's essentially as a kind of transfer of risk. We all bear risks. And unless we do something about it, we are personally responsible for those risks. So in law and legal analysis, we say you are self-insured. In other words, you're going around this world, you're bearing the risks, and you're going to compensate and meet whatever is lost. Well, insurance is very different. I can move from self-insurance, professional insurance. So now, when I actually meet up with the risk and the material loss, I can pass it to somebody else who's agreed to compensate. So, there's different ways of saying that. Of saying it's a transfer of risk, but in truth, what it is an indemnity. So if I suffer a loss, I've agreed with my insurer that they will indemnify me for my loss. So I still bear the risk, but not the consequences of it. And the basic mechanism for that is paying a premium. And that's a kind of the price you pay for the indemnity that you are obtaining. Okay? Now, with regard to insurance generally, it's very democratic. In the main, there's no compulsion. It's only wise to insure. Or as we put it, it is prudent to insure. But sometimes it's compulsory. And we'll look at that a bit later. Right? So, generally, I'm away from my home now, and all my little garden equipment is there. And I don't have to insure it. I'm not insured. I have insured it. Is it on the household insurance? And if somebody steals it, I self-insure. That's my risk. And incidentally, this is an informal session of the last question. as we go along, if there are any. And as I said, I'm going to select a few, so I will be, I've done some, not sure I get through the right ones. Just to, well, that will pass that. So just look at the pockets. So it's such a simple proposition, but just bear in mind, insurance is a contract. Simple as that. It's a certain kind of contract. So what about the parties? Well, the person who insures us, we call the insurer or the underwriter. The underwriter is the profession. This is the person who's protecting our interests, who's going to indemnify us. So I say person is going to be a company, obviously. And we, people who take out the insurance, are the insured or the uninsured. Now, these are the two terms as part of the market. I think whatever be the history of this, they need precisely the same. I tend to use underwriter and assured because it's safer than insurer and insured. They're very close together. And it's very easy to say when you're writing about these kind of things. So keep them apart. Now, a contract is between A and B. The rest of the world are outside that. But insurance, we ask the question very often, what rights would a third party under the insurance? And that is, in the real world, a crucialist. And of course, it's very relevant in maritime. Because we will see a little later, and I'll turn to this before I sit down, we will come across a lot of compulsory insurance. And the rights of third parties to move in and take the benefit of that insurance. So in legal practice, that's pretty vital as well. So these are the parties to the contract. So the contract defines the cover. So, you know, if you beg the question, right, do I have insurance? You've got to look into your contract. And of course, that contract may be encouraging or discouraging. If somebody comes into, into the office, somebody loses a house, goes up in fire, and they say, oh, come on, there's insurance and cover. I said, it's a step one, you're dealing with your contract. Step two is to see if household fire is covered by that. And if it is not, it's a very easy section. So it's got, and most people, out there in the real world, the we hear people saying, I've got insurance. Yeah. Quick look at a range. This is characterizing insurance by reference to the subject matter for the risk. Right. All I'm going to say, you see marine there, and you see all the others. They belong to the same legal world. If you know the principles of insurance, you can apply to any capital insurance. Right? They follow. Right? There's no real difference. And the one thing some people say, well, if you look at inshore, we have the Marine Insurance Act 1996. Which is a kind of codification that's as relevant to any principles of insurance as it is to the insurance. Quick introduction. I've used the word indemnity already, but there's also non-indemnity. And this is an insurance where you get a fixed sum for whatever risk you insure. So if you're unemployed, and you've got unemployment insurance, you might be able to pay a sum of X pounds or euros per week for the period of your unemployment. Plenty, or if you've got travelers insurance or whatever. Okay. So non-indemnity insurance is a different way of coming to the definition of the indemnity But the crucial difference for insurers and generally is, but with non-indemnity insurance, there is no right of subrogation. And subrogation relates to the rights of the underwriter once they are compensated. So if I compensate Frank for a loss he has suffered by reference to the wrongdoing of a third party, having indemnified Frank, I can now use Frank's rights to sue the third party. Now, that right of subrogation in commercial insurance is important, because insurers call it recoverance. And over a period of years, or of a year, 12 months, an insurer can recover and lock up the money just before. And it's also premium sensitive. So the greater the subrogated rights, the more competitive will be the pricing of your premium. And so the rights of subrogation, again, are very crucial. In practice, this is where lawyers get very much involved. Okay. And then we have mutual insurance and market or corporate insurance. And mutual insurance really is non-profit making insurance. The company insurance is a company with a capital structure and a profit motive is present. Okay. But mutual insurance is an insurance which is owned by the members of the club. And so they cover each other, but no profit motive. Cover the costs, operation costs, establishing reserve funds. Now that is crucially important to us because we have a P&I world. Where would shipping be without P&I insurance? Protection and indemnity, they are mutuals. The ship owners who are members, theoretically, are the owners of the club. They're both the members of the club and also will be insurers. And will be insurance provided. And I'm going to speak to you about P&I clubs later. And I'm going to allocate a certain period of time for that because knowing how they work is crucially important now. Very interesting implementation. Excuse me looking down, but I've done a little bit of editing in advance to try and help me. Very quickly about this, in passing, there is no international convention with regard to insurance. It's almost a bit of a relief for battle. So we operate generally. The only thing that you can say about that, why not English law is a little bit of an international law. It's already been mentioned how frequently cover is based on not only English law, but London market terms. Right? So it performs something similar, but obviously not in a formal way. And the marine insurance contract can be covered by any system of law you wish. If you've got a major ship that you just sunk for 50 million US dollars in an error, you want a serious legal environment and serious lawyers to deal with this. Okay. Possibly on that. Now, when you talk about insurance and contracts, we're talking about the others. So, the secret of insurance and the overriding principle is sharing the risk. So, if I'm going to insure a ship for 100 million US dollars, there's not one insurer that come in and take that risk. That people I can use 100 million, one strike. That insurer was probably wrong. I will not. Loan it. They will share the risk. Now, I'm not going to go into the details of how this is done, okay, because it takes us in too many different directions. So you could say, let's keep the mathematics nice and easy. So you go into the market, you have 10 underwriters, and they each take 10 million. You've got now, your insurance, the other side, I'm insured. And then when I look, my underwriter said, that's only 10 then. Wow. And there are streamlined ways of doing that. Doesn't mean you have to 10 different documents. But you have one policy and it's signed by 10 underwriters. Well, the underwriter has 10 million risk. That's an academic salary, that's the thing. So each underwriter will be insured. So you might reinsure 5 million. So if he takes a hit, he pays that 10 million, that's fine. So suddenly we've got 20 underwriters. And each reinsurer might then reinsure it. And we have what we call retrocession. So suddenly, insurance on this one ship, you might have 40, 50 underwriters involved in different categories. And lo and behold, one of the first underwriters, which was 10, might come in later under a retrocession law. So they changed their status from primary underwriters to reinsurers. So that's how the market's wise. And of course, today, that kind of spread can be throughout the markets as well. Not contained only in one market. But of course, once you do that, the brokers have to be very careful that they have a single governing law and the terms are going to be the same. Because once you break that, okay, so it can become quite a complex issue. Now I'm going to go forward a little bit. Well, yeah, let me pause it. The trouble is, every time I see a slide, I think I should pause and think about it. Okay, so, there's a kind of portfolio for your standard ship owner, as long as you can afford it. Okay. And in each category, of course, there are different levels of cover. So, hull machinery, increased value, water, we're talking about water strikes, right? Freight, fiscal cover, and then we have PMI cover. So there's quite a portfolio, but in simple terms, our ship owner will want hull machinery cover and certainly PMI cover. And provided you can afford it, of course, there's a cost factor here, you might have more. And we were talking about war and strikes here, the piracy, historically, was war and strikes really, that label indicates non-marine risks. The basic policy is dealing with marine risks, war, and then piracy can appear under any section, but generally it's now seen as a marine risk and not a war risk. I don't go there. Maybe I want to go next. Right. This is where students of the subject spend a lot of time, but we're going to find it. Okay? Because if we look at the cover, as we look at the contract, as I've emphasized already, our contract, one of the main purposes will be to define the cover. Say precisely, if you're looking at the hull and machinery ship, precisely what kind of risks are assumed. Now, the relevance of this contract is such that we've got to make sure that it is a legal contract, obviously. Secondly, that there's an insurable interest. So if there's a ship in the harbour today, down in Dubrovnik, I will get up and just insure it. Rhidian Thomas, is it? From East London. I think. Why don't you insure interest? I mean, if that ship was a sinking harbour, what would say? Nothing. But if I could insure it, you'd sank. But technically, I think the winner. I'm taking my 10 million. I wasn't at risk of it. So that's it. Sometimes it can be a little bit. Okay. But there is this division The dual idea that you have to have an insurable interest. And the insurable interest can vary. Every mortgagee of a ship will insure. But the mortgagee's interest in the ship is very different from the owner's interest. Because the owner's interest in the ship, the physical value of the ship, the mortgagee is interested in a security for the loan. Most of them have insurable interests, different kinds. So around the ship, you can have a multitude of different insurable interests. I mean, insurable interest rarely causes much problem today. The next one is a minefield. Because this is a contract that we have to faith. And that means that when you place this risk, you have to be comprehensive, fully cover all the risks and honest and truthful and exercise care. And if you haven't, you could lose them all. And of course, there are brokers involved. Right? So this is an area, not, this is a major thing. Huge amount of education. Rest assured that insurance has passed the stage of two men or women shaking hands. This is contract. You have a major claim today. The first thing that the underwriter does is to be gracious and say, thank you for presenting the documents in time. You leave the room, he picks up the telephone and he speaks to his lawyers. And they are presented with the documents and say, and asked, do we have to do this? And today we have a world of records, emails, everything is going. We misrepresented. We failed communities. It's an area you have to be cautious of, and it has grown. We could speak for a week on that in the different dimensions. But I'll pass it over in a couple of sentences. Indemnity, the sum you pay to compensate. Now, generally, you would have to work that out. But one of the peculiarities of marine insurance is, with regard to hull and machinery, the parties will agree the indemnity. So invariably, especially on the London market, you insure a ship and you will agree a value. So contractually, you agree the indemnity. So if that ship is lost, don't think anybody start valuing. When am I right? Just say, what he knows. And very often the indemnity can be beyond or less than the market value of the ship. So you have a ship worth 30 million, and you may be tempted to insure a proportion. And you're going to need to do that. You have to do that pretty careful. Because essentially, the owner may be under various pressures. Because he's likely to have a mortgagee bank. And the mortgagee bank has lent him 40 million. So they want to insure the repayment. So they want the value of that ship correspond with the level of debt. And also, the ship owner may be interested in a replacement, and he knows the cost of the replacement. So this is why you don't get this, go away, insure your car and say, can we have an agreed value on this car? Unlikely. But if you've got a 1925 Bentley, which I don't have, you might say, well, there would be a market. I could put something like £500,000 of that in the event of expense or total destruction. So one of the hallmarks of marine insurance, hull and machinery, is what we call agreed value policy. Of course, it's dangerous territory. So if the owner's in debt and he's about to pull the plug mid-Atlantic and sink the ship, well, you might as well put as much money on that damn boat as possible. So that's when they would like to ensure the ship for as much as they can. So when she goes to the bottom, the rest of the that would be a risky for us. Okay, let's everyone go to the lines. The question, I think, how is it that? This is kind of basic claims territory now. So we imagine our policy, we've insured the ship, we've mentioned the risks, peril of the sea, fire, breakdown, or whatever, and we have our agreed value. How do we claim? So essentially the stages. Firstly, have we suffered a loss? As defined as loss. This ship been lost, has it been damaged? Has it been a peril? Peril might be collision. Peril might be port damage. Yes? So we took it. And then finally, we've got to live together. We've got to say that the one was caused. So when she sank, it was caused by the collision, or caused by the wetland, or caused by the fire. Another question of causation, right, can be challenging. Now, the basic, it's got a legal aspect and a huge factual aspect. The legal aspect is to know what is the test of causation. Because you can have different tests. Some very demanding, others use. Well, the basic test in maritime is proximate. And I'm dealt with there are many people in this room who understand what proximate means. But what it really is meaning is the essential, the efficient cause of an accident. So it asks you to look at the situation and take a judgment based on your total viewing. There can be different causal tests, right? Which we're not going to follow because we don't want to do that. But this issue of causation can be troublesome. So the test is a test of law, but whether causation has actually taken place is a question of fact. So the judge has to apply the right test, and therefore, and thereafter, it is a judgment of fact. Okay, and very quickly, let's look at the Leyland shipping case. We have a ship coming down the English Channel, First World War. She's attacked by a German submarine, and she's damaged, but she doesn't sink. There's assistance from the French force, and she's towed into the harbour. She goes into the inner harbour in the half with the consent of the harbour master. And there, I mean, she can live, she's taken in water, but it's a very sheltered position. The harbour master then gets a little bit panicky because he's fearful that she's going to sink and affect the commercial operation of the boat. So he gives an instruction that she goes to an outer position in the port, still within the port. And in that outer position, she's exposed a little bit more to the sea. And looking at the floor of the tide, she's going up and down. And every time she goes down, she hits the bottom and then slows down. You know, the feelings you have when you man are saying distance. And it's saying, okay. And she sings. I'm going to say, there's my policy. Never mind about the nature. I'm sure. Somebody tell me, oh yes. I mean, there's no reward for this. What caused the Second Trip? War. War. Who said war? Yeah. Takes a lawyer to take the lead. Okay, so we go one for war.
Concurrent, of course.
Sorry?
Concurrent.
Oh, this man's a little bit of water for this. Yeah, we're not going to get you more. Okay, okay. That's the easy way out of this. It's very all the sea. Very all the sea. Okay, yeah. Any further ideas? See, I mean, before this case, the common law will then last effective legal jail. So the common law, someone would have said, pre this case, the movement within the harbour, and particularly in the last stage of it. But I was Supreme Court, I said, no, let's take a total, looking at it in the round, and we're right. They said this is a force. And the party was inaccurate there. It was more restrictive. They didn't have that. That was how much of that decision was. If they'd gone with a port, you had insurance cover. They went with and I think I agree with that to look at it in the environment. But it's, suddenly you have about a horse race involving 3 horses, and all of them are champion horses, which don't you look back on. See, I think this is gardening animals. Okay. University of Exeter case, recent case, very quickly again, right? And it isn't mine. So the University of Exeter only gives a plan for campus, which is nice. And they wanted expansion, and they wanted to build. So the site had to be cleared. So in they went to clear the site, and they discovered nothing on the second floor, which hadn't exploded. So obviously they employed, I suppose I think probably the military section, and they decided to detonate. So remember, that's my bomb went into that field around 1940, and in detonate, obviously they didn't judge things properly, it's part of the explosion, and the explosion damaged part of the established university. You know how good university planning is. So they said, what are the insurance policy? These 3 little things. Well, insurance are there. As I said, the day of the handshake is on. Insurance will take any technicality like that. Of course I don't. Boris. So you start with the law, you have the declination. There's no penalty to get it wrong. Somebody shut up. But it was a catalyst anyway. So no time. Fun? War. Yeah, okay, well, obviously, and that's what these people do. I have to say, why do you think that? That's 50 years between this. When that bomb project rested for eternity in that field if they didn't want to. I mean, to me, it's the detonation. And of course, again, war. University didn't have insurance. It was more risky. I was with the judge at first instance about 3-4 weeks ago, and I'm not very good. And we'll read because we're having to agree. And he said, sometimes when he said, the higher the case goes, the simpler the judges, because the trial judge will be agonized. And usually, okay, so I'm not going into the send or mockery. I've told one at a time. So let's see what I take now. Well, that's our technical. Yeah, okay, these could be. If you there's your hull machine. I mean, that's the ship. You insure the ship. Two things just to to highlight, notice, I mean, apart from the point that it's going to be a value cost, notice there is third-party liability collision cover in your balance sheet. Now, that exists quite strongly, which is so it's a bit of a mixed policy. So you get cover from your P&I club for third-party risk collision, and also under the hand. I mean, all these things can be varied. You know, but ultimately, it's a question of negotiation. Where are we? Cargo insurance, and not only insurance covers salvage and general damage as well. But when we come to cargo, the rule is different. Because cargo insurance is really beyond personal choice. Because cargo insurance is more often than not tied up with the international sales. The same directly contract when they. So when a seller is insuring cargo, very often he has to insure for the returns of his sale. He has no choice. And you've got the engine sequences, the agencies are all risks. You don't get all risks without, and that means essentially all risks means the losses that he caused by an accident. So we normally pay. So those are the two things to highlight there about cargo. Important strikes. Now I'm going to stop there because this is where I'm going to steer my clubs very quickly. Any questions? Okay. Now let's move into the world of P&I and the insurance that they offer. Let's do. So we know that P&I are interested in the third-party liabilities of shipowners, the partners, and way. So very material liabilities, not property and damage. And they offer a huge cover. I mean, it really is phenomenal. Just think of the risk that a ship owner can be exposed to, from personal injury to crew or passengers, up to salvage and general average, collisions, etc., etc., etc. And the terms now are found in the rule book. So when you join the club, you have a certificate of entry, and that entry will tell you precisely what you've agreed to cover, and the cover will be drawn from the rule book, which is essentially, so it's 12 months cover from the 20th of February to the 20th of February. You might say, why the 20th of February? Well, many years ago, that was the date when the Baltic forward. And on the 20th of February, trading vessels that enter the Baltic. Well, it doesn't read anymore, as far as I can see. But, those dates really sink. Now, and the other big difference, with your market insurance, you pay your premium. And that's it, for 12 months. Nobody can ask you for more. With a P&I club, you pay it forward. And if the P&I club wants more money, it will make an admission for.
And supplementary calls.
Well, okay, yes, okay. You've suffered the pain. And in theory, it could be a call after a call if they need the money. Because bear in mind, what is compensating claims now is the pooling of money by all the members. And of course, the leading P&I clubs, they're huge membership and they're huge organizations. Yeah. So this is more theoretical. But it does happen from time to time. And that's why your P&I clubs build up significant reserves. Because that's the last thing you want to do. Because they compete with each other. And they don't want to lose to major vendors. Because they're hurting them financially. Okay? Let's go. There's our group. As they now exist. And they all insure roughly on the same terms. The language of the rule book is varied, okay, but they're in the same category. Now, and this is the international group of P&I clubs. There are PMI clubs out there outside that. Some of them are significant. A lot of them are national. You have to be very careful. Very careful. There's a room and a place for them. Now, so these people insure, and I'll give you roughly what happens with insurance. Because they are also reinsurers. So each club will take a claim up to 10 million. So every claim up to 10 million is handled by the club. The club may reinsure that. Right? You've got to go in there, you're never quite sure. Strategically, they may play differently. Right? Between 10 million and 100, you go into the pooling agreement. And that means, right, that sum, that 90 million, is compensated by all the members in the group according to the terms of the pooling agreement. And this is the kind of insurance. And that's why every club, once that claim was over 10, then you could get very nervous, very excited, and do everything they could to keep it under 10. Because things can get nasty even between PMI clubs. And then you have major PMI clubs saying, why should we pay claims in other clubs? So it's a little sensitive borderline. And if the claim goes over 100 million, then the claim goes into the reinsurance on the markets that the clubs do. And that reinsurance takes you up to about 3.1 billion. Wow. It is super insurance. But it has to be paid for. And that reinsurance historically was all placed in London. Now around the globe. It's big coverage. So it's huge coverage, and it's a very strong setup. And quite frankly, without that, shipping would be very different. Our international conventions would have a very different shape, because now you can insure quite comprehensively, and that also is why the international group plays a very important part. A very important part in the development of international maritime. Now, I'm going to reduce this to a few observations. The internal management structure of the club, you've got to understand in order to appreciate how it operates. I can't keep the time, don't have the time going in. But what I'm going to emphasize is the hallmark of PMI insurance, there is a huge amount of discretion. On the market, it's firm rules, either within the contract or you're not. When you come to PMI work, with the managers, with the members club or the members agreement of committee, and then you have the directors at the top. And of course, all these structures are directors. They be drawn from membership, the ship elements, and the like. There is quite a lot of discretion. Two things I draw to your attention. The omnibus rule. This is quite remarkable, right? Because it brings in, if you have a claim and it's not within the terms of your contract with the club, but nonetheless it is what you might call a fair maritime claim, the club may agree to underwrite it. So you could be outside the terms of the contract, and yet the club will see it as a claim associated with the ship owner and shipping, and they will underwrite it. But the next one is the pay to be paid rule. So yes, the club insures liabilities, but it is only obliged to pay you in the main if you have discharged the claim first and you recover the payment from the club. So you have to pay the third party in order to claim reimbursement of the club. The pay to be paid rule, the pay first rule. You think about that and the liabilities to pay. But of course, it can be waived. Right? It's a condition. So I normally can't know this, to what effect it is with. But given the, the nature of claims today, where you can lose 10 million, in half a breath. So, but it's certainly, but as you see, there are exceptions. Those exceptions came in, the concession was made with regard to death and personal injury claims against the widow of a deceased seaman is not expected to be bound by such a rule. Okay. Let's move a little into compulsory insurance. So we started off 45 minutes ago. I think I have the time. By saying it's prudent, but there are terms, when you are paying to insure. But I mean, I think it's quite erratic. I'm not sure people detect any kind of policy here in Croatia. I mean, if you go to the UK, these are the compulsory insurances. Is there a flag of continuity there? So, employers' liability, riding establishments. My granddaughter is very pleased by that. Riding is nuclear installations, aircraft operators, international maritime liability connections, which are given effect by that. So, those are in the UK. I don't know about Croatia, but in there are. But it seems that there is no overriding policy. It's a kind of ad hoc decision made at the time. And look at motor vehicles. What do you have to insure in Croatia with regard to your car? You have compulsory car insurance in Croatia? Yeah. Okay, good. And what are you insuring in Croatia?
Liability.
Liability, third party, anything else? See, there's the philosophical question.
Total loss, yes.
Yeah.
That's what we would.
Right. Okay. But no, just sorry.
Without this car, insurance without machinery.
That's it. That's it. Okay. But see, there's philosophical question. Yeah. What you're compelled to insure is your liability with other drivers or people in passengers. You are not compelled to insure your own car. John Stuart Mill in the 19th century would be delighted with that. It was a reflection of a democratic principle. So therein is okay, you're doing that. Now the question is, once you have compulsory insurance, generally, if you just ignore the car or situation. So, emphasize, what are you protecting? Who are you protecting? Third one. You're protecting the person who was walking on the pavement and you ran over. But after the economy, have you really have access to your insurance? So without more, what is being asked and demanded is, but if you actually claim on your policy, and having received the money, then you compensate the third party. Now, what can happen? Hey, receive the money, and you still do that. Hey, but receive the money and fall bankrupt. And it goes into your estate. So the principle is good, but the procedure is defective. And therefore, when you have compulsory insurance, not always you will be looking at third-party rights action. So the passenger or the pedestrian is given the right now to sue under the driver's insurance policy. Shortcut, because you take all the risks. Now, when you have that, the big policy is if the third party has a right to sue, what are the terms of that claim? In other words, do the terms of the contract between the driver and his insurance company transfer to the claim by the third party. So that the position of the third party is precisely the same as the position of the assured. No. If it is the case, then the underwriter can plead against the third party all the defences that they had against the assured. Now, what's fine with regard to the terms of insurance? Well, what, for example, if the assured had broken the duty of good faith in place of insurance? So that insurance now becomes vulnerable. Can the underwriter plead against the third party a defence not under the terms of the contract, but a defence relating to the conduct of the assured in placing the insurance? Great question. Now, in English law, we have the third party rights against insurance act, Act, but generally that philosophy applies. There are. And if you put it, let's put it in penal insurance, would the pay be paid to you having that? With regard to a third party claim? Okay, so this is the dilemma, and this is where the world departs. Right? So in English law, it's a very rigid position. But if you go to the Maritime conventions, okay, and it becomes possibly more Rhidian influence. I don't know what position of integration might be with regard to what we're not talking about. Okay, but under the conventions, we have compulsory insurance, as you will all be familiar with, and there recognized third party rights. But the third party is given greater protection than the third party under insurance. Because under these conventions, the insurer can raise against the third party all the defences that are in the convention itself. In addition, they can plead one defence under the insurance, which is willful misconduct. And that's the only defence. And all the other defences that you might have just hinted at, like breach of duty of good faith. So in other words, what is happening there is the third party is being given a much more secure position. And the basis would be, why should the third party suffer because of the misconduct of the assured under the primary insurance? But at the same time, underwriters would say, this insurance might be invalid. It isn't valid or avoidable as against the issuer. It should be similar to the third party. It's a question of policy. And my interpretation of the international convention is that the third party is given a separate and independent right to sue the underwriter. It's not a mere transfer of risk. It seems on at least my reading. So
if the injured parties get the reflection against the insurer, and if the insurer says, however, the policy is out because the premium, for example, has not been paid for a long time, so policy is not.
Well, the insurance is ceased, not okay.
That's it.
Yeah, okay. I mean, that's brought the insurance to the head on the assumption that happened.
So the third party rights are subject to.
Yeah, well, obviously, yeah. If if you take up insurance and then you terminate, yes, that's it. So I'll probably that all by operation. Any further questions?
I guess the ship would be operating illegally then.
Will
Well, if the ship owner hadn't paid the premium, let's say for.
well, I'm not sure. Yeah, I think.
But he's operating the ship illegally under the convention.
Well, I'm not sure it would be a crime. But the ship's not gonna do much. I mean, the ship is then self insurance. And she's not going into port. You know, you will not get her into anywhere, to the port. And you might be breaking, you could be breaking the rules under the class A. But I don't think it would be necessary.
No, sorry,
Unlawful.
Purely from memory, I think the conventions have a special rule for non-payment of premium that the insurer then has to give notice, and only after a certain period of time, the third parties lose their protection. Because you also have.
That's not in the convention.
I think so.
Yeah, it might be some kind of rules of understanding, but I will check. That's the point of that, but okay. So you see, at the end of the day, we all provide that our area for international conventions and etc. And that also takes us to the P&I fund, because it's the international group of P&I firms who are insured all these conventions. And it's only when they give us a thumbs up that these conventions become meaningful. Because if they were not there to underwrite the risks, well, I'm not sure how the insurance. I'm sure there'd be insurance, my goodness me, much more limited for conditions. Okay, over to Frank. Thank you for your attention.